The time limits with regard to an estate action are kind of fluid. Probate can take, the actual probate of will can go quite long depending on if someone is going to object to it. If objections are filed with regard to a will, you can go, and it goes through the whole process, up to theoretically a jury trial. It could take a year and a half, I would think, just depending on the court's calendar, to actually get this resolved. Although very few cases actually go that way. That's pretty unusual, but it could take a while. In the meantime, however, one of the useful aspects of a will is that if you name an executor, that person, even though the will is not admitted to probate, could get what's called preliminary letters. And that person can then administer the estate, collect the assets, pay the bills. They cannot distribute any of the assets to any of the beneficiaries. But they can get the job done in order to deal with the estate. And that's very useful as if there are problems. Once a will's admitted to probate, or step back, once a will, the person is appointed preliminary letters, an estate has to be open for 7 months. The estate will not close. The court won't close an estate because creditors have 7 months basically to come out of the woodwork and make claims. After 7 months, the estate can close. Now that doesn't mean you can't make distributions. If I'm the executor, I can make distributions, although I want to be careful because I want to make sure that I have enough money for claims if they get filed late in the estate, because if you make distributions, my experience is once you give it out, you can't get it back. So you got to make sure that there's money available if someone files a late medical bill. But after 7 months, you can then conclude the estate.